Hi, everybody. Thank you for joining me today and welcome to our Facebook live audience. Today, what we're going to be talking about are the 6 essential steps of do-it-yourself probate. Now, probate can be a pretty complicated process. It all depends. And my goal is to provide you some essential information just to help prepare you for if you ever face that situation. So my name is Lynn St. and I am an estate planning and elder law attorney in Washington State. Before we get started though, I do want to mention that if you are listening, if you are interested in probate, that could mean that you are dealing with a really difficult situation. The probate process happens when somebody has died. And so if that's your situation, I want to extend to you my condolences, because that may mean that you have experienced the death of a family member or a friend or a loved one. And I think that is in part what makes probate more difficult, is that you're dealing with grief and you're dealing with loss, and then you're overlaying on top of that a probate process. So I just want to make sure that we acknowledge that part of a probate process is dealing with loss. And so my heart does go out to you if you have experienced the loss of a loved one. Please stay with us throughout this process. This is being streamed live on Facebook, but if you are attending the Zoom, go ahead and just type your questions into the chat box and I will answer them at the end. Stick with me to the end, because if you do that, well, you'll get all the information, but we'll also be able to share with you a probate checklist. And if you're on the Facebook audience, just email webinar@elgwa.com and we will provide you that checklist. Also, for the people that are attending live, there will be an offer at the end as well that we'll be talking about. So let's go ahead and get started. What is probate? We'll get into the 6 essential steps, but what is probate? So probate is the legal process to administer a decedent's estate. What is a decedent? A decedent is the person who has died. So when somebody dies, there is a legal process through which their assets, their estate is administered. The person who does that, the person who is responsible for that, is called the personal representative. And we'll be talking about what the personal representative's job is, but pretty much their job is to do it all. And that's what we're going to be going through. There's one person who will be responsible for administering an estate, and that's called a personal representative. All right, essential step number 1, open the probate. Sounds simple. Opening the probate, what is involved with that? So first of all, you need to figure out who is going to be the personal representative of the estate. Who is going to have that legal authority? The personal representative of the estate will be the person who is nominated in the will. So the will should say that so-and-so will serve as personal representative. What happens if there is not a will? Well, then we'll get into that, but there will still be somebody who is a personal representative. It's just that that person has not been nominated by a will because there isn't a will. So usually a probate is opened within about 30 to 60 days of a person's death. Lots of times families contact us right when somebody has died, and I tell them, please take the time to go through the grieving process. That's the most important thing for you right now. None of the business of the estate has to be handled immediately, but oftentimes people do want to, have some guidance. What should they do? So for a do-it-yourself probate, take a little bit of time to make sure that you've dealt with the loss, the grieving process, and then if you're the person who's been nominated by the will, or if not, there's no will and you're a family member, what do you need to do next? What you need to do next is open the probate in the court. Well, how do you open the probate in the court? There are legal pleadings that are required. There is a petition to admit the will or a petition to start the probate if there is no will. If you're the personal representative nominated or you want to serve in that capacity because there's nobody else nominated, you need to prepare an oath. There is an oath that where you swear, you write down that you will do your job, because being a personal representative is a job. It might be considered an honor, but more than anything, it's a job, and it's a job you have to do if you're going to accept that position. So what happens is you fill out the petition, you fill out the oath, you prepare an order, you take it to the court, there's a filing fee of $240 to start the probate. You take the original will and you have the judge then sign an order that says, yes, this probate can start because this is the original will, this is the person who's nominated, they've done an oath, and here is the order signed by the judge. Now, once you have opened this probate, the next step that you do is you want to get what's called letters testamentary. So with the order, you go to the clerk's office and you get letters testamentary. That is your legal authority to conduct business on the part of the estate. So you've probably heard that term before. Letters testamentary are critically important to administer the estate. That's your authority. If there isn't a will, they're not called letters testamentary, they're called letters of administration. But they have the same authority, which is you have the authority to do whatever has to be done on behalf of the estate. Kind of think of the letters testamentary sort of like if you had a durable power of attorney for somebody while they were alive and you had the legal authority to act on their behalf while they are alive. Letters testamentary are like that, but for a decedent. One of the things that people are often surprised about, I just wanted to mention, is that when somebody has died, the durable power of attorney document dies with them. So there is no longer any legal authority for the attorney, in fact, the person who's been designated as that power of attorney. Instead, to get the authority, open the probate, file these pleadings with the court, get the letters testamentary, and then you have the legal authority to conduct business on behalf of the estate. All right, so that's step number one. This is a good question, and I think I'll answer it now is, do you have to open a probate? No, I mean, there's no requirement that anybody have to open a probate. So a couple of things. Sometimes no probate is necessary. Lots of times when we set up estate plans for people, we do it so that there won't be a probate, either through the estate planning documents we did, or sometimes it's because a revocable living trust exists. There's a lot of reasons that there may not need to be a probate. Perhaps the estate is small, it has under 100,000. Then all is needed is a small estate affidavit. There's a lot of reasons why probate is unnecessary. And so that's one of the first things you're going to want to find out is, before you do the filing fee and pay the $240 to open up the probate in the county where the decedent resided, do you need a probate? So that's a really good question to answer first before you go through all of that work. Let's say a probate is necessary. Do you have to serve as a personal representative just because you're nominated? No, you don't. If you choose not to, then the next person who's nominated would have the right to step up. Let's say there's no will, there's nobody nominated, but you're the family member. Do you have to serve? No, you never have to serve as a personal representative. But usually there's a reason people do want to serve. They want to wrap up the business of the decedent, or there's assets to distribute. So that is definitely a motivating factor, is the assets of the decedent aren't going to go anywhere unless somebody does this work if it needs to be done. Sometimes estates are just debts, no assets. And in that event, you let the creditor do the work of probating the estate because they're the only one that's going to get anything. So kind of a long-winded answer to, do you have to open up a probate? I would say it depends. Do you have to serve as the personal representative? No, only if you want to and there's a good reason for you to do so. So that was step number 1, opening up the probate. Step number 2 is, now the probate's open, you have to notify people who are entitled to notice. So who is entitled to notice? And this notifying has to be done by the personal representative within 20 days of the judge signing the order on the probate. Who do you need to notify? You need to notify everyone who is named as a beneficiary in the will, that they are a beneficiary of the will. You need to notify anyone who is a beneficiary of a non-probate asset if you know that, for example, they are going to receive the IRA, which you might not know. You need to notify everyone who is an heir at law. Who is an heir at law? An heir at law is anyone who would receive from the decedent if there isn't a will. But in my example here, I'm saying there is a will and it says who are the beneficiaries. So perhaps the will says that they're a single person and they're survived by 3 children, and 2 of the kids are going to get the estate and the third gets nothing. They're disinherited. So even though they're getting nothing, this third child, the personal representative still must notify this third child that they are, and the reason that there is a probate, and the reason for that is that they are considered an heir at law. So all heirs at law, and there's a statutory definition for who that is, but all heirs at law must be notified that the probate has started, even if that person gets nothing. So that's a really important step that has to be taken, because if you don't notify the people, and I'll get to the entities who need to be named, then that can draw out the probate process. See, probate should not take terribly long. There's a 4-month creditors period. And once that period is done, and once all the assets have been gathered up and any tax returns have been handled, then you should be able to distribute out the assets. But if you haven't given correct notice, that can prolong a probate process far beyond that. Who else needs notice? The state needs notice. So you have to give notice to the Department of Revenue and the Office of Financial Recovery. The reason that they need notice is they might have a claim to the estate. So OFR, Office of Financial Recovery, with DSHS, they might say, oh, well, we paid benefits on behalf of the decedent, and therefore we're entitled to recoup whatever benefits we paid from the estate. So you need to give notice to the 2 state agencies, in addition to the beneficiaries and in addition to the heirs at law. I think step number 2 is the step that most people miss when they do a do-it-yourself probate, because how are you supposed to know that? That's a really important step not to miss. Step number 3, gather up all the estate assets. So you're kind of a detective at this point. What you're doing is you have to determine, well, what did the decedent own? So, you probably know that they own their house and their car and their stuff in the house. But then you got to figure out, well, what are the bank accounts? You have to find out the bank accounts, investment accounts, brokerage accounts, life insurance. A lot of times people don't even know that the person who died had life insurance. How do you figure this out? Well, you're the personal representative. So what you do is you go through all of their personal papers to make sure that you see, like, what bills have they been paying? What premiums have they been paying? Do they get monthly statements? And in this digital age, when people don't necessarily get things in paper anymore, how are you going to figure out what statements they're getting? I mean, do you have online access? Because you know what their logins are. So this is what I'm saying, that you really do become a bit of a detective when you are the personal representative. So the idea is you gather up all these assets. Oh, and another thing is, you might want to check with state agencies. If they worked for, the state, do they have a pension? Is there any survivor benefit for the pension? Social Security. Typically, the funeral home contacts Social Security to let Social Security know that the person is deceased. Veterans Administration, were they a veteran? Contact them to see what benefits there might be. So at this stage, you are gathering up what the assets are and making what are the necessary contacts, as I've explained. That's step number 3. One of the things that I do want to point out is that when you do your estate plan, you can make things a lot easier for people. So let's say that you have thought through this yourself. Maybe you've been through a probate. You know how much work it can be, and you don't want to put your family through that. You want to make things easy. How can you do that? You can make things easy by just doing a list of your assets and who to contact and passwords. When we do estate planning for our clients, I don't know if you can see this, but we put everything into an estate planning notebook. And in this notebook, there's places for people to put their wills and their asset information, and they can do a letter to their personal representative. This is a gift that you can give to your family to make it easy on them. They're already dealing with your death, and that's tough. Try to make it easier so that what they have to do once you're gone isn't a difficult job. So a well thought out estate plan can make things a lot easier for folks. And along the lines of making things easier, let's say that you've already done an asset list while you're alive. So your personal representative says, oh, here's an asset list. They just need to take that and then turn it into what we call an inventory. An inventory is something that is part of gathering up the assets that the personal representative does need to do. They don't need to file the inventory with the court, however. We do not file inventories with the court unless there's a darn good reason. That reason is that a beneficiary has requested the inventory or a creditor has requested it. Now, if a beneficiary has requested the inventory, that tells me that the personal representative hasn't done a really good job with communicating with the people who are going to inherit. See, if you as personal representatives say to, the other people who are going to inherit, I'm working on this, this is what it looks like, approximately the asset level is. People want to know what they're going to inherit. They might have these notions of it's going to be a whole lot of money. And if you say, mom's estate consisted of the house and she had a bank account of about $200,000. So that's what, the 3 of us are going to share or whatever, makes it much easier than if people have notions that they're going to inherit a lot more. And if they are kept in the loop about what things are looking like with the asset level, the beneficiaries likely aren't going to request an inventory. So, we prefer that no inventory ever have to be filed with court. One of the things you might have heard about probates is that probates are really, really public. Well, they're not really, really public. What I mean by that is when we do a probate, when the law firm does a probate, we file the will with the court and the petition on that first step when we open the probate. And all we say is that assets exceed debts by $10,000. That's it. There's no suggestion that the estate's worth $10,000 or $100,000 or $1 million. You don't have to do that. So at least in the state of Washington, probates can be quite non-public, other than the will is filed with the court, and especially if there's no need to file the inventory. So an inventory is something that does need to be done as a part of the process. Now, if you're doing it yourself, and you just have you and your siblings, are you going to need to do an inventory? Probably not on a do-it-yourself probate, because you don't have to file it with the court, and as long as you're all getting along and there's no creditors, then it doesn't have to be done. Question here is, what if assets are jointly owned? So, good question. Assets that are jointly owned with survivorship, do they go through the probate process? Probably not, unless they were jointly owned with the intent that they should go through the probate process. And I don't mean to double talk here. The situation with jointly owned assets is sometimes people put, let's say mom has 3 kids and she puts one of the kids on the investment account so that it's easier, so that when she dies, they don't have to go through probate. Well, that may lead to no probate, or it may lead to family litigation because mom maybe didn't intend the one child to get the whole investment account, but the child said, oh yes, she did. I'm the only one on this account. I own it jointly. It doesn't preclude the other 2 kids, for example, from saying, no, that's not what mom wanted. She wanted it to go to all of us. So family dynamics, family litigation happens with or without a probate. It really is a part of, was the plan clearly communicated? Is it clearly set forth that this jointly owned asset should go to the one other owner or should not? So litigation is something that you hear of a lot with probates, and that's because what you hear about are the messes that happen. We try to advise clients that they don't set up their estate plan so that it in a way that would lend itself to litigation. Here's a question for me. When you use an affidavit, a small estate affidavit, remember that's the one when you're under 100,000. Do you still need to contact the state departments? Yes, you do. You need to let them know you're using a small estate affidavit, because they are still going to review their records to see if they have any claim against the decedent. So the question about co-ownership of property. Let's say mom co-owns a house with her sister. Is it going to go through probate or not? It depends. I know you've heard this a lot from lawyers, this answer. It depends. Depends on how they hold title. If mom and sister own title as joint tenants with right of survivorship, then if mom dies first, sister gets the house. No probate. That's just how the title's set up. What if mom and sister hold title as tenants in common? Then what happens is mom's half interest in the house goes through her probate, so not to sister, unless mom's will said, I co-own a house with my sister, I want her to get it. But if mom instead, her will says, I want my assets to go to my 3 kids, then mom's half interest in the house then goes down to her 3 kids through the probate. And that could result in sister either having to buy out the 3 kids' interest that was mom's before she died, or some other solution. So when you're looking at real property, you want to get the last vesting deed, and you want to do this as part of the estate planning process before somebody dies, so that you can fix things before the person has died and not have a probate that wasn't intended result. We see that a lot. Probate, whether it's going to be required in home ownership, again, depends upon the title of the asset. If the house is owned joint tenants with right of survivorship with the other owner, no probate, goes to the other owner. If the house is owned tenants in common, the 2, mom and sister, then mom's half interest will go through probate to the son, for example. This $100,000 small estate affidavit thing we talked about, that does not apply to real property. Small estate affidavit is not available if the asset we're talking about is real property, regardless of the value of the real property. If it's under 100,000, doesn't matter. Small estate affidavit does not work. So the best way to find out how things are titled is to get the title of the asset and take a look at it. And if you have questions about, well, what does it really say, you can talk to a title company or reach out to an attorney to help you. Let's go on to step number 4 and keep those questions coming. I love the questions, and I'll take them as they come if they apply to what we're talking about. Otherwise, I'll wait till the end. But please, I really appreciate the questions. Step number 4 is evaluate and pay creditors' claims. So one of the reasons that we gave notice to OFR, Office of Financial Recovery, is they might have a creditor's claim, or they might have a lien, actually. Credit card companies, they often have creditors' claims. And the thing is, with paying the debts of the decedent, it depends again about what's the debt. Is the debt a mortgage? Well, then that is already secured by the property. They don't have to do a creditor's claim. They already have a claim. But what if it's a credit card? Maybe mom ran up $10,000 in credit card debt. Well, then what we would want to do is to use the creditor's claims process to potentially extinguish that claim. So how do you do that? If you know of the credit card company because they just sent a bill, you're the personal representative, you said, oh, my mom owes $10,000, then what is done is the notice to creditors is provided to the credit card company. So I haven't talked about the notice to creditors yet. This is another step. This is step 4 in the process, notice to creditors. So what a law firm will do is we'll take the notice to creditors and we will file it in the county newspaper, the legal newspaper. Here we do the Spokane Valley. And it gives notice to the world that, hey, if you have a claim against mom, you have to bring it within 4 months. And if you fail to do so, in the legally prescribed way, which there are very strict rules how to do it, then you are out of luck. You cannot collect. That's notice to the world, publication that we give. That's that 4-month creditors period. Well, what if we actually know the creditor? It's not notice to the world. It's like we know that there's a credit card company. Then what we do is during this 4-month process, like about 30 days before the end of it, we send the notice of creditors directly to the credit card company. And we don't give them instructions. We don't tell them what to do. We just send the notice to creditors. And if they don't, within that 30 days that we give them a 30-day window, if they don't file the requisite form with the court and serve it on the personal representative, then they have not met their obligations to a properly filed creditor's claim, and there is no obligation to pay that $10,000 debt. So it is an opportunity to extinguish debts, to make sure the estate is cleaned up so that whoever is going to receive it receives what they should get, and that they don't have to, a year down the road, face a creditor coming after them because it wasn't done right. So it's a really good opportunity. Now, what can you not extinguish? Last illness, funeral expenses, those have to be paid. And what else has to be paid? Taxes. So if, mom owed any kind of income tax, the state has to pay that. You can't get around that. So part of the process is making sure that tax returns, not just the year of the death, but you should look back and make sure that there's no liability from several years ago so that you're not facing an unexpected IRS bill. Tax returns are important to do as a part of this step. We're just making sure that everything that has to be paid will be paid at this phase of the process. Okay, so that was step number 4, probably the least fun stage of the process. Okay, step number 5, maybe this is the best phase of the process, is distributing out the money. So you've gone through steps 1, 2, 3, and 4, you're at step 5. Now it's time to distribute the money out. How do you do that? It can be easier or it can be more difficult. It's easier if everybody is on board. So let's say at the end of the process, there's the 3 kids, there is $300,000 in the bank account. Everybody's going to get $100,000 from the estate account. You heard me say estate account. That's part of the process, is that when you're marshaling and gathering up all the money, you take it from mom's bank account and you put it in a new estate account. You need a new tax ID number to do that. So you've done that, you've got $300,000 in a bank account. Now it's time to distribute it out to you and your 2 siblings. Great. If everybody is in agreement, what they'll do is they'll sign a receipt, and the receipt says, I'm getting all the money that's coming to me. And if you get everybody to sign that receipt, then you can give everybody their checks for $100,000. The money is distributed out. It's done. It's pretty easy. Where there isn't that kind of agreement and cooperation, and somebody says, oh no, you owe more money, or mom had more money, show me the inventory. That makes it really hard to do it yourself probate at that point, because you know that people aren't getting along, and likely they're going to lawyer up, you're going to need to lawyer up. And that's means you take it from do it yourself to, oh no, this is a litigated probate. So hopefully that doesn't happen. If you don't get agreement, then there is a formal notice process that you go through so that you can distribute out the money. Again, you hope that that's not the situation. Now, I didn't really talk too much about the will should say where the money goes. If there is no will, the laws of intestacy say where the money goes. If mom was a widow, she only has 3 kids. The laws of intestacy say that the 3 kids inherit. What if one of those kids didn't survive mom, but they left 2 kids? Then that deceased child, their 1/3 share goes down to their 2 kids. So the laws of intestacy, when there's no will, it does make it a bit more complicated, especially if you're trying to do it-yourself probate. Do you have to do a Form 1041? That's an estate tax return. It really depends on what the assets of the estate look like. If mom's assets were such that, hey, they're investment accounts and that they are generating more than $600 in income to the estate, there might need to be a 1041 filed. We always recommend when we're working with clients to use an accountant to make sure that the right tax forms are filed. Because if you don't file the right tax forms, there are some big penalties that the IRS imposes. Next question is, if there are no debts, can step 4 be skipped? You mean you don't do notice to creditors? You can skip notice to creditors as long as you're willing to accept the risk that maybe you were wrong, that there weren't any debts. But my caveat to that is, as long as you make sure that the IRS is paid. That's a critical piece to make sure you're not dealing with a tax liability. So this kind of goes to the distribution of assets and whether how you can protect assets. So the question is, if there's a special needs trust for a disabled child, is that protected from financial recovery entities? The answer is that if the decedent owed money, then as a general rule, the special needs disabled child, that their inheritance might have to pay whatever is owed to the state agency, for example. But, and this is a very large but here, is that let's say that the amount owed to the state agency is because of Medicaid. Well, in that event, assets that go from a Medicaid decedent to a special needs child or special needs trust, no, those are exempt from state recovery. So definitely, if you're dealing with anybody that's been receiving government needs benefits, either decedent or the child, talk to an attorney, because there are definitely exceptions to the rule that the state has to be paid back. For example, special needs trust child doesn't have to have their inheritance impacted by Medicaid benefits that mom receives. So great question. So it's a little bit more complicated, definitely than do-it-yourself probate, but it's great questions to be asking. And then if the beneficiary of an estate, what if they're in a nursing home? Then it would have been really important that the decedent set up in their will a trust for the person who is in the nursing home, because in that way, the person who is receiving, the person who's in a nursing home, if they have a trust created by mom's will, then they can stay on their benefits, but still get the money because the money is in a trust. and it doesn't therefore interfere with their benefits, doesn't knock them off benefits, the state will never get those benefits ever, get any of that money, yet they'll still pay. So setting up a special needs trust through a will is a really great estate planning tool. Oftentimes though, we find that mom's will didn't do that, and then the person is in a nursing home who's inheriting from mom. If they're under age 65, you can set up a special kind of trust. It's called a D4A trust, so they can stay on their benefits. But a D4A trust does have state recovery. So just by a little bit of good estate planning in advance, you can ensure that there's no payback to the state. Great questions. Now, if the decedent owned property, not just in Washington, but in Idaho and maybe some other jurisdictions, then what? Well, there has to be an estate administrative process in each of those states. So as a part of people's estate plan, let's say that they own property in California, Idaho, and Washington. Well, we're going to be talking with them about making sure that their California property is set up in a revocable living trust to avoid probate there, because probate in California, I am told, is terrible and expensive, whereas probate in Idaho and Washington is really simple. We often do probates in Washington and an ancillary in Idaho, and it's very easy to do. But the more complicated somebody's estate is, the less likely that you're going to do a do-it-yourself probate, because it just gets too complicated. So, just keep that in mind. Okay, so we have distributed out all the assets. Step number 6 is close the probate. I just mentioned how easy it is in Idaho to close a probate. You don't even need to do anything. You just kind of walk away from it. In Washington, what is done in Washington is the personal representative completes a pleading that's called a declaration of completion. And that just tells the court, hey, I'm done doing my job. Everything's been done. And so now, court, you can close the probate. So that is called a declaration of completion. And typically when we do that, we file that with another declaration that the personal representative signs that says that they did their job, making sure there were no creditors, and if they were paid. We typically file it with the receipts from all the beneficiaries. But for do-it-yourself probate, what you just need to keep in mind is a declaration of completion is the pleading form that you would then file with the court, and then that is what brings the probate to a close. There is this process, again, do-it-yourself probate is anticipating that you're not having problems, you're not having it really complicated, that you got everybody to sign a receipt form that says, hey, they got their share. If you don't get those receipts and you file your declaration of completion, you have to give notice to people who are the beneficiaries of the estate that you're doing that. They have a 30-day time frame to file an objection with the court to say, hey, no, the personal representative didn't do their job right. So again, if you're dealing with that kind of formal process, 30-day notice period for objection, that doesn't lend itself well to a do-it-yourself probate. So that's how you close up a probate and go through the 6-step essential process. And I'm just going to go over that really quickly again, which was step 1, open the probate. Step 2, notify interested persons and agencies of the probate. Step 3, gather up all the assets. Step 4, evaluate, pay creditors' claims, make sure taxes are paid. 5 is distribute out the assets, and 6 is file the declaration and close the probate. Question I have here is, how is an estate closed that did not go through probate? It's a really good question, because lots of times estates don't go through probate, particularly if you're talking about spouses, 2 married persons. They often don't do a probate on the death of the first one because they don't need to. They might have signed a community property agreement that says everything we have is community. So everything goes by way of joint titling or beneficiary direction. Both of their names are on the house. There is not a need for probate oftentimes when the first spouse dies. So maybe there wasn't a probate on the death of the first spouse. When it comes to estate planning, that may be the right way to go. It may be the wrong way to go, but that's not what we're talking about. There oftentimes is no probate on the death of the first spouse. Well, what if there's a single person that dies? And what if there is no probate? Again, at some point, if somebody wants to get the assets, there's going to have to be some sort of estate administrative process to get those assets. The period for a probate typically runs 4 to 6 months. And why I say that is there's that 4-month creditors period. And so let's say the personal representative does everything, just, they're on top of it. Usually you close out within 6 months. During that 6 months, you can sell the house. There's all sorts of things that you can be done. You're not just waiting for that 4-month creditor claim process and doing nothing. The PR personal representative is doing their job. But let's say it's been a year, the person has died, nobody has done anything, or maybe it's been 2 years. You can still open up a probate 1 or 2 years or 3 years after a person has died. But the probate can be opened when somebody realizes, hey, something should have been done. There is an estate administration that should have been done. The longer you go out, I think it just makes it more difficult because, what happened to that asset during that time frame? The bank maybe has paid it to the state fund of unclaimed accounts. You may have heard of the term escheat to the state. Not quite sure if I said that right, because we rarely use that term. But what that means is, hey, if nobody claims anything, it goes to the state where they keep all these assets. And you can even look online, unclaimed funds for the state and see if you have any. We did that recently, and one of our paralegals found that there was $70 waiting there for her. So probates are typically done within the first 1 or 2 months, but sometimes it goes on. People don't realize of a need until 1, 2 years or even more. Okay, so this is an estate planning question. And the question is, let's say there's a couple, it's a blended family, and maybe the will says everything goes to the surviving spouse. What's going to happen with the children who may have been the children of the deceased spouse who are not the children of the surviving spouse? This is a really, really important part of estate planning. Oftentimes what we do is we set up trusts so that the deceased spouse's children will inherit. Sometimes families don't do that. And depending on what the will says and how things went with the probate, it could be that the children of the first spouse to die are effectively disinherited. They end up getting nothing. And that could be because that was the intent, or it could be because that was just poor planning. So getting good estate planning in place is the best way to make sure that there is not an unintentional disinheritance of the children. Thanks for hanging in with me so long, guys. I'll keep answering questions as long as people are posing them. So, for those people who said, hey, I only had 45 minutes, if you want this probate checklist, let me share it with you for those of you who can see it, and then I'll come back to questions. So just email us, webinar@elgwa.com. We'll send you this probate checklist. You might be able to see it on my screen. It's, the same sort of steps we went through, just a little bit more detail than what we talked about in this checklist form. But send us an email at webinar@elgwa.com, and we'll send this checklist to you. For those who are interested in learning more than what we're able to cover, feel free to call us at 509-468-0551 or go to our website, elgwa.com. If you have participated in this webinar and you're listening to me now, and what I want you to know is our firm, let's say you've decided, do-it-yourself probate, I've tried it, or I don't even want to try it, I'm overwhelmed. We typically do charge a consultation fee of $375, but if you call us and say, hey, I just listened, Lynn was talking about do-it-yourself probate. We'll offer for you a complimentary consultation. Just come in, you'll speak with one of the lawyers. We'll do that complimentary for you. That's kind of one of the benefits of staying with me to the end here is give us a call. We'll give you a complimentary probate consultation. It's going to be within certain parameters though. If you call and say, hey, my brother is doing this wrong, he's the PR, I'm going to sue him, that's not going to be something we can help you with. Part of what we do at ELG Estate Planning is setting up the estate plan so that there are not problems. I used to do litigation. Over 20 years, I was a litigator. And when I pivoted my practice to doing estate planning and elder law, one of the reasons I did that is I wanted to help people proactively make things, set up a good plan, not fight. And so I had 20 years of fighting as a litigator. We don't do that anymore at ELG Estate Planning. That's just not part of our practice. So if there is a situation where you need to be represented because it's a probate gone bad, we'll refer you to litigators. That's just not our practice area. So the email, and you'll see it in the chat, it's webinar@eljwa.com. All right, so let me get back to a few questions for those that I haven't yet answered. Is who are the heirs at law? I love that question because it's the statutory scheme. So I'm going to go through who the heirs at law are. So let's say you are married and it's a blended family and you have 3 kids from a prior marriage and you die. Your heirs at law are your spouse and your 3 kids. Your heirs at law do not include your spouse's kids, your stepkids. Those are not your heirs at law. So heirs at law are spouse and kids. Let's say you don't have a spouse. Heirs at law are your kids. Let's say you had 3 kids, but one of them didn't survive. Then your heirs at law are your 2 surviving kids and any grandchildren from your deceased child. Let's say you don't have kids. You're single. Who are your heirs at law? Then you look up. They are your parents. Let's say your parents aren't alive anymore. Then your heirs at law are your siblings, brothers and sisters. Let's say you have a deceased sibling. Then the niece or nephew of that deceased sibling stand in the position of that deceased sibling as an heir at law. So it's this statutory scheme where you go down, you go up, you go out. So heirs at law are, as I say, it's statutory. If it's an heirs at law question, I'm sure you could Google research, RCWs, that's the Revised Code of Washington, heirs at law. But if that's your situation, you might want to just check with an attorney as well. Thank you so much for the compliment from one of the listeners about the importance of doing an estate plan, and that basically glad that they had our office do it. I really appreciate that. Thank you so much. Okay, Colleen says she is going to email this checklist to everybody who registered for the webinar. Again, if you have any questions, feel free to reach out to us. Our phone number is 509-468-0551. That's 509-468-0551. And you can reach out to us at webinar@eljwa.com. Feel free, if you have other things that you want to learn about, have me talk about, just send that to us because I love doing these, educational events where I can, help share information. Even if you've had an estate plan done by us or by somebody else, sometimes it's just hard to understand exactly how things work. And so happy to answer your questions and do more of these presentations. Again, thank you all who joined me today, and I'll be signing off. Thank you.